Right, well, I think we should make a start, and other people will join us when they're able to. My name is Steve Naffler, and I'm delighted to welcome you all to Landmark Chambers seminar on adult social care law. This is the last of 4 social care webinars that we've been running, and today we're covering first the interaction of health and social care services, second, contractual disputes, third, difficult assessments of needs, and 4, data protection and social care. It's great to see so many of you joining us today, and we hope the presentation is going to be useful and even enjoyable from time to time. To begin with, there are a few housekeeping points. Your microphones are automatically muted, so you won't need to adjust your local settings. Your videos are automatically turned off, and if you accidentally turn them on, please turn them off again. Questions are absolutely welcome throughout the session, so if you wouldn't mind submitting them through the chat section, you can text them in through the chat section at the bottom of the screen, and we'll answer as many of them as possible at the end of the presentation. Actually, the last one we did, there weren't any questions, so it'd be really good if someone thought of a question or two this time. But it's obviously completely up to you guys. If there are so many questions we can't answer them all, we try and answer everything we can after the event. The webinars can be recorded, and the slides and recording will be uploaded to our website and apparently to something called YouTube, which you know, I don't know, people might know about that. So, and if your connection is lost at any point, you just have to click on the original link once more, and you'll get back in. So I'm going to do just quite short introductions to everybody this time, so we've got a lot to get through today. The first speaker is Leon, and a lot of you will have already heard him talking about ordinary residents and local authority and health authority disputes in that context. So now he's going to talk about the interaction between health and social care. He was called to the bar in 2011 and specialises in public law, in particular, as many of you will know, social care law, and in particular within that education law. I think it's fair to say he's been all over the place, from the tribunals up to the Supreme Court and the European Court of Human Rights. He was involved in the Alfie Evans litigation, which went from the High Court to the European Court of Human Rights, I think in about 2 months or something like that. He's involved in the challenge to the NHS Accountable Care Organisation contract, the Yorkshire Rivers move from Broadmoor. He's highly ranked in Chambers and Partners and the Legal 500. He's described as incredibly bright and able to get to grips with cases quickly, clear, concise, and cuts through ethics details. It's on the Attorney General's C panel, acts for Secretary of State, commercial organisations, families, local authorities. He's also on the Equalities and Human Rights panel. He's done lots of fantastic things. Probably the best thing he's done, in my personal opinion, is contributed some great work to effectively the landmark book on adult social care law, and the other one, sorry for the shameless plug, the children's social care law. And so I'll now leave you in his capable hands. Leon.
Thank you very much. And if that was Steve giving a short intro, I'd like to see what his longer intros are. So I finished a book about a couple of weeks ago called A Short History of England, and it was about 400 pages, written by Simon Jenkins, highly recommended. And this talk, in many ways, what I'm trying to do is similar to that book, is cram a huge amount of material into 15 minutes. So I aspire to the conciseness of Simon Jenkins, and the way I'm going to do that in looking at health and social care is to split this talk into 3 segments. So the first segment is an introduction to NHS bodies, their duties, and the concept of the responsible commissioner. These are fairly basic concepts in the context of NHS law, but they may be less familiar to those of you who don't practice in it regularly or practice in the main in social care. So that's segment one. Segment two, I'll look at continuing healthcare, and that's the area in which I think most social care lawyers will come into contact with CCGs and healthcare law generally. And lastly, I will look at the relationship between health and social care in the hospital discharge arrangements arising from COVID-19. And the reason I'll finish on that is because there are a few queries in relation to that I've received, and it may be useful to set out a bit of background on that topic. So let's kick off then with a short introduction to the NHS and the NHS bodies. The starting point is NHS England, whose duties are set out in the NHS Act 2006, and that act essentially contains all the statutory material you need in relation to the NHS. So its duties are set out in that act. Its general duties are to promote a comprehensive health service, exercising functions, continuous improvement of services, reducing inequality, promoting research, and a whole list of duties, and those are replicated in relation to CCGs, as well as other healthcare bodies. Now, what's important, I think, probably for present purposes, are its commissioning responsibilities. So what is NHS England responsible for in terms of commissioning? And there are specific things it's responsible for, set out in the Act of various sections, notably primary care, dental care and specialist services. And so primary care is essentially GP surgery. So every GP surgery will have a commissioning contract with NHS England. Now, moving then on to CCGs, and these are the bodies which I think local authorities will probably be dealing with most. So clinical commissioning groups. What are they? They are bodies made up of GP surgeries. So I've just said that the NHS England will have a contract with a GP surgery. It also has a duty to ensure that each of those GP surgeries are part of a CCG, and it will probably be the CCG in whose area the GP surgery sits. Now, in terms of commissioning responsibility, CCGs cover the majority of commissioning of health services, and that includes hospitals, services in hospitals, community health services, and for present purposes what's important is commissioning for continuing healthcare, and it's in that area, as I said at the start, that local authorities and those involved in social care will most likely come into contact with healthcare law. So that's the CCGs, and then lastly we have NHS trusts. Those are essentially the deliverers of many health services. So if any of you know or are doctors, for example, they will generally be employed by a trust. The trust provide goods and services, so they may run a hospital or do the actual providing of services. So in our canter through the bodies who are responsible for healthcare, let's not forget local authorities, because local authorities have duties in respect to public health, which some of you may know, some of you may not. Each local authority has a public health director, and the head of that structure is actually the chief medical officer, and that many of you will know is Chris Whitty, who has reached a level of fame he probably didn't expect about 6 to 8 months ago. So each local authority has, it must take steps as it considers appropriate to improve the health of people in its area, and it can provide various things like advice, services, assistance, and making other services or facilities available. So local authorities also make up a relevant body in terms of delivering health services. Last topic by way of introduction to sort of the concepts in NHS law is the concept of the responsible commissioner. Now, the division of responsibility between local authorities can be amazingly complex, and many of you know, and I spoke about last time, in respect of the Care Act, it's the concept of ordinary residents. And you will recall, or you will know, that in the case of Cornwall Council in the Supreme Court, I think it was 4 local authorities turned up to say that they were not the person who was responsible. So that is how complicated that can get. It's slightly easier in respect of NHS or continuing healthcare or that kind of provision, because the CCG responsible is the CCG in which the GP or the individual's GP is a member. So where the individual has a GP, the CCG of which that GP surgery is a member is the responsible commissioner. Slightly more complicated where, as you can see from subsection B there, where the individual does not have a GP, but the majority of people do. And so it's very common where you've got social care provision, residential social care provision, and that individual moves, that individual will then move GP surgery to be close to where they now are. And it will be that new CCG that will pick up the can of being responsible commissioner. So that deals with then that's the first segment, as it were, of my talk and my canter through the introduction to NHS and healthcare services in the context of social care. So the next one I'm going to cover is continuing healthcare. And this is a concept I'm sure many of you will be familiar with and come into contact a lot, but just to go through the basics. So what is it? It's the provision of health services to an individual by a clinical commissioning group or by the NHS. And why this is important in respect to social care is really in 2 ways. The first is for the individual, because where an individual is entitled to community health care, and therefore it's delivered as a health service by a CCG, they are not charged for that service, so it's free at point of delivery. However, as you will know, in terms of social care, when that is delivered by the local authority, it's subject to a means test and it's often charged for. So it can make a huge amount of difference for individuals. For public bodies, it also makes a big difference, because it is the difference between the local authority carrying the financial responsibility for potentially quite a lot of provision, or the CCG. Because if continuing healthcare is granted or an individual is eligible for continuing healthcare, the local authority will generally determine there's no need for community health services. And indeed, actually, as you can set out section 22 of the Care Act, as set out at the bottom there, the local authority isn't even allowed to deliver services which are health services pursuant to the NHS Act 2006, except for in a couple of cases. So that's why it matters. We then move on to what is the test for whether someone is eligible for continuing healthcare. And the concept here is the concept of a primary health need. This is set out in the national framework, and that framework is essentially a Bible for continuing healthcare. All your questions will be answered in that framework. It's available online, so look there as your first port of call. The concept is set out at paragraph 54 onwards. I've picked it up there at paragraph 55, where it sets out an individual has a primary health need if, having taken into account all of their needs following completion of the decision support tool, that I'll come back to in a moment, it can be said that the main aspects or majority part of the care they require is focused on addressing and or preventing health needs. Having a primary health need is not about the reason why an individual requires care or support, nor is it based on their diagnosis. It's about the level and type of their overall day-to-day care needs taken in their totality. So it's a slightly elusive concept. Now, I'll expand on that in a moment, but let me just deal with the decision support tool. The process by which continuing healthcare is assessed by a CCG is there is a multidisciplinary team who essentially make a recommendation, and they make that recommendation after filling in the decision support tool. It's a standardized form with standard questions. That then goes to the CCG, who then makes a final decision on eligibility, and they have to follow the decision support tool or the MDT unless there are exceptional circumstances for doing so. So let's come back to the concept of the primary health need and see if we can shed any more light on that. It essentially is whether with a touchstone essentially whether it's health services that are required or social care services that are required. And in terms of how the local authority will be looking at this, someone is ineligible for continuing healthcare only where the nursing or other healthcare services required are no more than incidental ancillary, or are, this is important, and not of a nature beyond which a local authority whose primary responsibility it is to provide social services could be expected to provide. So that's why it's quite important then that the local authority has a say or is represented in the process, because they will have a view on whether what's required is something the local authority will generally be expected to provide. And the CCG has a duty to consult the local authority as set out there. It is known that local authorities are involved in the multidisciplinary team stage, but the framework requires them to be consulted at least before the eligibility decision is made. Now, where the local authority disagree, and so the CCG essentially say, well, there's no primary health needs, so the financial responsibility falls on the local authority because it's social care rather than healthcare. Well, the starting point is the decision of whether an individual is eligible is for the CCG. That's set out in that St Helens case. The local authority doesn't have a veto over the call, but it's not uncommon for the local authority to disagree strongly with the local authority, with the CCG, sorry. Now, the local authority doesn't have a right of appeal, and what Regulation 22 of the relevant regulations, I've set out the full title of those in the previous slide. What there needs to be is dispute resolution protocols. Now, these will therefore vary from area to area, and often because we don't live in a perfect world, there aren't any protocols. So what happens in that case? Well, I would suggest the CCG should be offering mediation or some kind of ADR. Or sometimes the CCG suggests using their complaints procedure. I'm not sure that's the ideal solution. Otherwise, you can end up in quite a messy judicial review. And I'm involved in the moment where there is a council and potentially 4 or 5 CCGs, and it becomes a situation that no one really wants to be in. So the key is deal with these points early on and get them dealt with. But what is absolutely crucial, and the court's made clear and the guidance makes clear, they're set out in the continuing healthcare framework, it's also in relation to the local authority guidance, is individuals shouldn't fall through the cracks. So tomorrow, this is on my mind because I'm fighting a case for a baby where we've got a local authority who says only minimal social care support's required because it's primarily health needs. The baby has primarily health needs, and the CCG says there are clear social care needs, but they are not health needs. So a clear case of where someone has fallen through the cracks. So the principle, and all public bodies, whether it's CCG or local authorities, should bear in mind there shouldn't be individuals who miss out because of disputes between different bodies. So that then completes the continuing healthcare segment of my talk, and I'll lastly move on then to hospital discharge during COVID-19. Now, this arose because the Department of Health and Social Care published guidance in an attempt to free up beds where there were concerns about capacity. And it set out a fairly aggressive approach to identifying and discharging appropriate individuals. It set out a discharge to assess model with 4 pathways, and CCGs were meant to take the lead on ensuring individuals would be able to go somewhere with a discharge, but that obviously involved local authorities too. And the guidance says CCGs would need to work hand in glove with adult social care colleagues, and that kind of reminded me of that famous moment in the O.J. Simpson trial where the glove doesn't fit. But anyway, councils were advised or asked to take certain steps, but one of those, and that's point 3 below, is to take the lead in contracting certain services. Now, what the government also said was it would, because it wasn't going to, there weren't going to be CHC assessments, it was going to fund all these pathways, but the actual financials were left to a local level. So most essentially what happened was agreements were made between local authorities and CCGs under Section 75 of the NHS Act, which allows that to happen where it would be appropriate for healthcare essentially to be delivered by local authorities. And there were agreements in place for the funding. Now, that means that almost every legal question that has arisen, the answer is in the Section 75 agreement. So that's sort of the starting point if anyone is dealing with disputes in relation to this issue. One thing that's come up, which is quite interesting, is where individuals were previously self-funded, they then go to hospital and then are discharged, and then their care is through the fund. But then at what point does the fund stop and then the local authority have to fund social care again? And that's been something I don't think there's a clear practice on yet, but I'll be corrected if I'm wrong if anyone knows of such a practice. Essentially, I think the answer to this is that it will generally be in the agreement, but what is relevant is paragraph 10.11 of the guidance, where it states that where a patient's been admitted to hospital essentially and was previously in receipt of a funded care package, the funding, the pooled funding, is intended to support the restart of such a package also. The key here is, what does restart mean? Does it mean a temporary period until the agreement runs out, or does it mean a longer term agreement? I think a local authority can probably push and say, actually, the funding should continue in the care package because there's still not been a CHC assessment. So that is, I think, all I had to say about that. And I will now hand back over to Steve, who will introduce the next talk. Thank you very much.
Thanks, Leon. Really delighted to introduce the next speaker, Admas Abdeslassi, who was called to the bar in 2014, and who had a very interesting career before he came here, which involved working for the UN Refugee Agency in Jordan, where his fluent Arabic no doubt came in handy. Coming top of the University of Pennsylvania Law School as a postgrad, and then being a judicial assistant to Lord Neuberger, where he probably didn't need his Arabic quite so much, but and since joining Chambers, he's joined the Attorney General's C panel. Like Leon, he's written some very interesting chapters in the adult social care and children's social care books, and appeared in a raft of cases across the public law field, including a number involving health and social care, in particular relating to people from abroad. And I know from my own experience, he's got a particular interest in social care, contracting, commissioning and procurement cases, and that's specifically the contractual area is what he's going to be focusing on today.
Thank you very much, Steve, and good afternoon, everybody. So the topic of my talk is contractual disputes in the social care field. I'm going to start by setting out some of the broader context and also the statutory context in the form of Section 5 of the Care Act. Then I'll say something about potential public law challenges, principally in relation to the Section 5 duty, and also more briefly say something about private law disputes and the private law, public law overlap, given that this is an area where both of those areas of law can be in play. These slides are in a lot of detail and are actually produced for a longer talk, so they're all going to be available on our website, but I won't necessarily be going through every single slide, but rather we'll be picking out the key points. So the broader context will be familiar to all of us. 2 points. The first is a shift to a market-based approach to the provision of social care services since the 80s and particularly in the 90s and noughties. And secondly, local authorities nevertheless remain the focal point for legal duties such as to assess and meet needs. And the key legislation, as we all know, is the Care Act 2014. Section 5 is of particular relevance in the contractual dispute context. It sets out a duty, which is the core of the duty set out in bold there, to promote the efficient and effective operation of a market in services for meeting care and support needs. That's the duty, and the red text indicates that that duty is with a view to ensuring that a person in the local authority area has access to services in the market, and those three things: essentially a variety of providers, a variety of services, high quality services, and sufficient information to make an informed decision. In discharging that duty under section 5.1, a local authority is required by section 5.2 to have regard in particular to 6 factors, and those are mandatory factors that the local authority has to have regard to. And just from glancing over those factors, we can see that it's quite a broad range of factors that are at play there. Some of them relate to matters that the local authority needs to be aware of. It has to have, for example, per subparagraph A, information about the providers of services. It has to be aware of current and likely future demand, paragraph B. Some of those factors are focused on users of services, so making available information, ensuring that adults with need for care and support can participate in education, work or training if they need to. And some of those factors are very much directed to the market and to providers. And a clear example is subparagraph D, which we're going to come back to, but also subparagraph E, the importance of fostering continuous improvement in the quality of services. That's something that comes from the provider. So it's a multifactorial exercise that section 5.1 and 2 together impose on the local authority. And the effect of those provisions together is just summarised in that slide. There's also statutory guidance, which is local authority is required under Section 78 to act under that guidance. I'm just going to skip through the market shaping principles just to highlight what it says about what the local authority is to have regard to when commissioning services. So cost effectiveness and value for money, certainly on one hand, but also there's a need to commission services so as to shape and influence the market, enable a certain level of quality of care, ensure that staff are properly remunerated, and ensure that there are a range of appropriate and high quality providers. So just from that short list, we can see there that some of these duties can be pulling in different directions: value for money, cost effectiveness on the one hand, and ensuring properly remunerated staff, high quality of care and so forth, which will tend towards high costs on the other hand. Just a few extracts from the guidance there that I'm just going to skip through. So in terms of section 5, those bullets there just summarise the main points that I've set out. In practice, the process into which that duty will feed into will coalesce into a contracting arrangement of some sort. So in addition to public law duties, the section 5 duty, there will also be obligations under contractual arrangements. And that's really the backdrop for consideration of contractual disputes in this context. Because of that context, local authorities will and the fact that local authorities will enter into contractual arrangements with private providers, contracting disputes can straddle both private law issues, that is to say based on contract law and the contracting arrangements, and also public law issues, because the local authority is obviously acting as public authority, is bound by public law obligations and so forth. So there is scope for claims and disputes on either or both of those bases. We'll start with public law challenges, about which I'll have a little more to say before moving on briefly to private law. So the normal grounds of public law challenge apply. To be noted is the position under ECHR. Article 8 claims by providers, we do see attempts to ventilate those, appear to face quite a serious obstacle in Section 7 of the Human Rights Act, which requires the claimant to be a victim of the contravention of the right. But claims on the basis of Article 1, Protocol 1, peaceful enjoyment of possessions, those would appear to be possible. Consultation and breach of the Section 5 Care Act duty are two that I'll particularly highlight, which I'll say a little bit more about. Dealing first briefly with consultation, just set out there a few examples of points in the guidance where the importance of consulting appropriately is really underlined, and the guidance makes it clear that local authority will need to work with others and to engage with stakeholders, partners and service users to understand the position in order to comply with the guidance. So those are clear pinch points for potential consultation challenges. And in order to ensure that it's complying with all of those requirements, local authority will need to give quite careful thought to designing a process for establishing the relevant contractual framework. The preference is for a comprehensive process which allows for all of the statutory factors and the factors set out in the guidance to be weighed, considered, taken into account with sufficient engagement with providers, users and other stakeholders, and a formal consultation process, all of that feeding into and culminating in a contractual framework at the end of that process, as the culmination of that process. So moving on from consultation to section 5. So one focal point for disputes in this context is the contractual rate or the fees that are set for services. And the duty under section 5 of the Care Act, and specifically the factor at section 5.2d, which we looked at earlier, which refers to the importance of sustainability in the market, has really provided a solid public law basis to ventilate such disputes, which on their face might seem like contractual disputes about how much should be paid. And the background, of course, is the fact that the local authority will generally be in a dominant position in the social care market. And so the prices that the local authority will set will have a very significant influence on the operation of that market. So what is the approach that the courts take to challenges of such sorts? A challenge to standard fees or rates on the basis that there is a breach of the Section 5 duty. Well, there is a case study in the recent, or relatively recent, 2017 decision in Care England against Essex County Council. That was a challenge brought by a charity and representative body for care home operators against the county council. And that challenge was brought on a number of grounds, including that a fee increase that had been introduced by the council, so there was an increase in fees, did not go far enough, both for the purposes of Section 5.2d and because it was irrational. Mr. Justice Lavender made some useful, at least for local authorities, clarificatory points about the scope of the duty under Section 5. The judge noted that Section 5.1 doesn't confer specific rights on individuals or providers, that there are means other than setting fees for meeting the Section 5.1 duty. It's not necessary that you need to increase or set a particular fee in order to discharge that duty. Further, that one aspect of promoting efficiency can be ensuring that fees are not set too high. On the other hand, the sustainability factor, so the 5D factor, can point towards ensuring that fees are not set too low. So that's quite a helpful clarification of the scope of the duty. In terms of the actual challenge, Mr. Justice Lavender made two key points. First, he emphasised the link between the factors in Section 5.2 that the local authorities are required to have regard to, and Section 5.1, which is the purpose to which those factors are directed. That is to say, ensuring that people within the local authorities area had the three things specified in Section 5.1. In that case, the judge found the Section 5.1 objectives were being met. In fact, it was common ground. And he said this was relevant to the approach to Section 5.2, the clear inference being that where those objectives are being met, it's going to be more difficult to make out a breach of Section 5.2. Ultimately, the judge dismissed the challenge on the basis of the Section 5 breach, finding that the council clearly did have regard to the importance of ensuring sustainability. And he noted that provided that they had some inquiry into the factors, it is generally a high threshold to succeed in relation to the manner or intensity of inquiry not being relevant. and particular emphasis was placed on the fact that the council had regard to a range of materials, including a pricing report which looked at all of the statutory factors. That significantly undermined the claimant's case that Section 5.2d had not been discharged. Mr. Justice Lavender also made some comments which are helpful to local authorities in the context of responding to the rationality challenge that was made by the claimants. He emphasised that a case that there was a certain level of increase which was necessary to meet Section 5 duty involved the judgment that the court would in general find very difficult to make. It was essentially an evaluative judgment, multifactorial, and very much for the local authority. And further extracts from the judgment there. Just summarising those key points in relation to Section 5 challenges, and particularly important to bear in mind the importance of strong evidence, particularly for a claimant, to be able to show that the local authority did ignore the statutory factors in setting the fees. And obviously, without evidence setting out the process, the local authority will find itself at significant legal risk of such a challenge. So that's public law claims. Private law claims I can deal with more shortly. They're essentially going to revolve around the contract, disputes about what the contract means. Does an arbitration clause apply to the dispute? Where a price review mechanism specifies a certain frequency of review, can that be changed? Or disputes around termination and the consequences of termination. And just a couple of examples from the case law where the court has found that what they were in substance private law disputes. And just highlighting some of the procedural points in relation to private law claims, particularly noteworthy where there are both private and public law points being ventilated, is that the limitation period in a contractual claim is obviously significantly more generous to a claimant, 6 years versus 3 months in the JR, and that there is less scope for early resolution of or early dismissal of claims in the private law context, absent strikeout summary judgment, which in my experience judges are more reluctant to do than administrative court judges are to refuse permission. So those are points to bear in mind. Sometimes the question of whether it's a private or a public law dispute can arise, and the short point is that simply because one of the parties is a public authority, that doesn't convert a private law claim into a public law claim. The test is whether the claimant can establish a relevant and sufficient nexus between the contractual action and the statutory public law duty. And for our purposes, it would seem that Section 5.2d seems to make this test considerably easier to meet, and Care England is an example of that, where the breach of the duty was relevant to the decision to set fees in the contract. Just for your reference, the slides, there are a number of examples there of courts deprecating approaches by claimants and defendants to cross-fertilise between private and public law claims inappropriately. So just the key points then from the presentation. In relation to private and public law, is the local authority exercising public powers? If so, judicial review is appropriate procedure, or is it a purely contractual dispute, in which case private law proceedings will be the way to go. A final point just to bear in mind is that competition issues can arise sometimes. I've just set out two examples of that, one in an inter-provider dispute and the issue of the local authorities being in a dominant position in the market, potentially raising issues under the Competition Act. No case has been brought so far on that basis, but it's something to be aware of. So that's just a summary of the main points made. I won't repeat those. I've put in a few tips for claimants and defendants respectively. So just to wrap up on those, for claimants, where it's a Section 5 Care Act public law claim, can you dispute Section 5.1 objectives being met? That will probably make the claim a little easier. And is there good evidence of a failure to take into account a mandatory factor? And that's really a slam dunk in terms of a judicial review claim, because those are factors that the local authority is required to take into account. As mentioned earlier, in the context of pricing disputes, Section 5.2d is a strong answer to the sufficient nexus test and will generally allow for a public law argument in relation to a pricing dispute, depending on the claim, but in general. Keep an eye out for consultation issues and see the guidance and the pinch points that are identified there. Public law challenge most logically will be to the formal process leading to the production of the contract, but there may be arguments that reconsideration is required in light and taking into account all the statutory factors in light of some change of circumstance. I've dealt with challenges on the basis of arguments that the effect of COVID-19 on care homes is such a factor, for example, and just bear in mind the potential procedural benefits of private law litigation. For defendants, in terms of Section 5 of the Care Act, it's just the other side of the points made in relation to claimants, really. Can you show or agree that Section 5 on objectives are being met? Is there good evidence of the mandatory factors being taken into account? And again, where the contractual scheme results from an extended decision-making process, a good argument is that that should be the only target for a public law challenge. You can't subsequently pop up and challenge the contract or things done under the contract. Those issues have been dealt with in that process leading to the formation of the contract. And public law claims are generally procedurally more favourable. Thank you very much. That brings my talk to an end.
Thanks, Admas. Right. If I can get it to work. Difficult assessments of need. So the first slide here sets out the statutory machinery for assessments. And helpful though it is, it doesn't provide much in the way of guidance that addresses the one really important issue that regularly confronts adults, carers, family members and local authorities, how to address a really serious dispute over what the adult's needs for care and support are. And that's what this talk focuses on, those difficult assessments and reassessments that you come across where there are hotly disputed issues and sometimes difficult personal relations, and where the problem seems headed towards litigation or a complaint to the Ombudsman. So I'm going to focus on what the local authority needs to do and what it can do, since the duties and powers in the Care Act bear on local authorities primarily, but everything I say is obviously going to be relevant to people on the other side of such difficult assessments. So when it comes to judicial review, in this context, local authorities do start off with a built-in advantage. Many claims will fail because of the alternative remedy provided by the statutory complaints process, and many claims will fail because of the circumspect approach of the admin court in this context to assessments, eligibility decisions, and care and support plans, as all of those cases tell us. But not always. That competitive advantage, that built-in advantage that local authorities have in the judicial review context, as all local authorities will be acutely aware, starts to become a rather thinner when a complaint is made to the Ombudsman. And of course, judicial reviews do succeed in challenging assessments where there's been unfairness or a clear failure to take into account relevant matters. And the recent case of JG and Southwark is an example of that, where the assessment simply failed to take into account 3 critical factors. But yes, a local authority may win a judicial review, but even if it does so, it's not likely to recover its legal costs. It certainly won't recover the time spent by its officers on the litigation, and the litigation may leave considerable disharmony in its wake, storing up trouble for the future and even reputational damage when the local authority succeeds. So of course the aim should be to resolve a difficult situation as harmoniously as possible. Now, the first bit of advice one can give when a difficult assessment is in prospect or underway is really very simple, and it is simply make sure and take special care that the assessment is a good one, in the sense that it conforms to all the rules and guidance. There are a lot of rules and guidance in the statute, in the regs, and in the care and support statutory guidance. They're all quite well known, and I'm not going to drone on about them, partly because, as we all know, social workers tend to use pro forma assessments, which help them ensure that the rules and the guidance are complied with, and partly because I set out here a compilation of all the basic requirements and what they are here, and here, and here, and here. And I'm not going to say any more about them, but instead focus on just some of the particular features of an ordinarily good assessment process that I think are particularly relevant where a difficult assessment or reassessment process is in prospect or underway. And firstly, advance information. Reg 3, 4 and 5 of the care and support assessment regs require the local authority to provide information about the assessment process in an accessible format and prior to the assessment wherever possible. And the purpose of that is to promote the adult's involvement in the assessment process, to make it a personalised process, and to reduce the likelihood of disagreements and adjust expectations. At the very least, it should help the adult concerned feel the process is careful and respectful of them and their wishes. And hopefully, that's because it actually is. Para 6.22, 6.38 of the statutory guidance emphasise the importance of giving the person concerned as much information as possible in advance about the assessment process, to ensure that there's going to be a personalised approach, to ensure that they're involved as much as possible, make sure that the format is accessible. Obviously Braille is used where that's important, and even it's suggested, provide the list of questions in advance to help the individual or carer prepare for the assessment, think through what their needs are, so on and so forth. So that's one kind of set of measures that can be undertaken at a very early stage to make life easier for everybody and hopefully more harmonious for everybody concerned. But another issue that arises quite early on is support. This is section 67 of the Care Act 2014. So the first thing that one does as a local authority is ascertain whether the adult or carer, despite having relevant capacity, is likely to experience substantial difficulty in participating in the assessment. So if that is the case, the first step is to see whether there's a suitable carer who can be involved on behalf and in conjunction with the adult. And if not, there is a duty to provide a suitable advocate. And assessments have been quashed because of a failure to provide a suitable advocate, independent advocate, in a case where the local authority has accepted or had to accept that the individual concerned had a substantial difficulty participating in the process. So the third type of thing to be considered right at the outset is self-assessment. Most adults are entitled to insist on providing at least the first draft of an assessment, and that can be really helpful for both the adult and the local authority, insofar as it should crystallise how the adult sees their needs and what it is that the adult wants, and that should force the local authority to engage with exactly how the adult views their needs, and that of course is exactly what the local authority needs to be doing in any event. And it's Reg 2 of the assessment regulations which requires authorities to ascertain whether the individual wants there to be a supported self-assessment, and which then entitles adults with the necessary capacity to undertake an assessment jointly with the local authority, and then the guidance sets out further help about that. So the next sort of preliminary consideration is who should the assessor be? Who should the person be undertaking the assessment on behalf of the local authority? And there are some sort of basic issues here. The first one relates to specific basic and specialist expertise. Reg 5 of the assessment regs requires that the person carrying out the assessment has the skills, knowledge and competence to carry out the assessment in question and be appropriately trained. And that means that they have to have the expertise for ordinary cases and whatever specialist expertise might be needed in a particular case. And that is expanded on in 6.85 to 6.90 of the guidance. 6.90 specifically says where an assessor doesn't have experience in a particular condition, such as autism, learning disabilities, mental health needs or other conditions, they must consult someone with relevant experience. And as is well known, the regs, Reg 6 requires an assessment of someone who's deaf-blind to have specific expertise and training relating to deaf-blind individuals. And there's a wider consideration here as well, that it sometimes happens that an adult or a family member or an independent advocate and the assessor just don't get on. Neither of them may be at fault. It may just be one of those things, or one of them may be at fault, or both of them. It doesn't really matter. The fact is that it may be possible, simply for that reason, to find an assessor as a replacement assessor without imputing any fault to the original assessor or a second assessor, just to come in and help out, or to use the need for specialist input in order to bring another assessor in that kind of difficult case. Sometimes, of course, help from the outside is actually required. Under Reg 5 of the assessment regs, the local authority is under a duty to commission expert evidence in any case where it considers it's necessary to do so. That may be health expert evidence, for example, occupational therapy expert evidence, and often it will be a really good idea for a local authority to bring that independent viewpoint in a case of difficulty, even when it's borderline as to whether or not it's needed or not, just to take some heat out of a particular situation. There's a power to delegate under Section 79, and some authorities may have delegated wholesale. But in any case, it can sometimes be useful to use that power to delegate to bring in, for example, an independent social worker from outside to take the heat out of the situation and to contribute, or even to carry out the assessment in particular cases. Well, obviously the local authority will be legally responsible for it, and sometimes it will be useful, particularly from a local authority financial perspective, obviously, to bring the NHS in if there's the possibility of the NHS continuing healthcare machinery being brought to bear. Another preliminary consideration, what kind of assessment process does there need to be? Reg 3 requires it to be appropriate and proportionate, and so it also requires the authority to have regard to the wishes and preferences of the individuals, the outcome the individual seeks from the assessment and the individual's needs. When it sort of frames the assessment process, and the Care and Support Statutory Guidance emphasises again the need for transparent and collaborative approach. So there's again a lot of scope at the beginning of a difficult process to try to discuss with the individual and their family, and obviously vice versa, and to try to reach some agreement about the parameters within which the assessment will take place. Now, so a classic example of a really difficult assessment is where the adult refuses to undergo the usual assessment process, but where the local authority is still required to undertake that assessment process. But I mean, the first thing to look at from a local authority perspective in that type of case is whether the local authority has actually provided adequate advance information and support of the type that I've just been discussing, because all of those are designed to foster cooperation and an agreement over the assessment process. So where an adult is refusing to undergo the assessment process, then the first thing to do, I think, is to make sure that all of those initial steps have been properly and sensitively undertaken. If they have been, and the local authority is still refusing to undergo an assessment, in some cases that's it, but in some cases the local authority still has to carry out an assessment, and those cases are all set out in section 11 of the Act, and I've summarised them here. And these provisions apply both to adults and carers. So very little in the statutory guidance about this, and I think all you can say is that in this sort of case, the local authority just has to do the best it can to produce an assessment that accords as closely as possible with all the usual requirements of an assessment, for example, by taking into account the information that it may already have on file, speaking to third parties who have a professional involvement. In an appropriate case where there is the possibility of abuse, it may be necessary to make an application to the Court of Protection or the Family Division for protective orders to be made. Cases of possible reduced needs are obviously a potential recipe for a huge amount of conflict. Nobody, for understandable reasons, wants to be told that their needs have reduced, in particular if they suspect that this is all part of a cost-saving exercise, as of course it sometimes is. So it doesn't always happen, but the court usually, and the Ombudsman, in my experience, pretty much always, looks with particular care at assessments that conclude that a person's needs have reduced. And the cases indicate, and I've just set out the bullet points here, what's required in this sort of case. A fair process where the assessor gives the adult a fair warning of what the assessor may decide in terms of an assessment of reduced needs, a fair explanation of why, a fair opportunity of responding, a meaningful opportunity of getting the assessor to change their mind or not reach the conclusion that they're minded to reach, an assessment that explicitly refers to the early assessment and provides a frank explanation of what's changed, and a proper record of the process, and in particular the assessor's reasons for disagreeing with the adult. In short, an intellectually honest process, I think, is probably a decent summary of the case law. Practical steps, again, you know, the statutory guidance doesn't really give you much help when it comes to this perennial thorny issue, but these are some of the examples of things that good practice that I've seen over the years, which have often, not always, often diffused seemingly intractable disputes over assessments. One, you know, just change the assessor. There may, even if it's not clear that there's a personality problem, but sometimes there is, even if that isn't clearly the case, it's remarkable sometimes if you can get one assessor out of the situation and bring another one in, how speedily things can magically seem to clear up. And if they don't, from a local authority perspective, if there still is a seemingly intractable disagreement, and I suppose, you know, without wanting to be cynical about it, at least you've then got, you know, two assessors and possibly more, possibly a third, who have got into that situation, hopefully despite using their best endeavours. Adding a second assessor, obviously, for the same reason. Getting some sort of external specialist report, potentially with the adult exercising some choice. And that's a perennial recommendation that I make in cases of care home closures in particular, other kind of service closures, clearly people are going to be worried about the effect on residents' health in that kind of case, in particular if it's a care home with especially vulnerable individuals involved. Well, you know, joint reports from the local consultant geriatrician, local authorities do that all the time, and it does, the reports are usually say exactly what one would expect them to say, but because there is that element of choice on the part of the individuals concerned and their families, and that independent element, it can often take a lot of the heat out of the situation. Again, an independent social work report, I can understand a lot of local authorities won't want to go down that road, but if, you know, if you are aware of sensible, even-handed independent social workers, the cost could pale into insignificance compared with the cost of litigation. And again, if the individual can exercise some choice, all to the good. Delegation is pretty much the same kind of thing. Early referral to a manager of an overview. Obviously, as a last resort, there's the statutory complaints process with perhaps, well, ideally, some sort of deferral of whatever decision may be in prospect. Also, mediation. It's such an unused remedy in this context, but whenever I've seen it used, it's been incredibly successful at diffusing the most seemingly intractable and sort of hostile of situations. So when a claim is threatened, the lawyers obviously get involved. And I'm not going to sort of labour this. The lawyers among the audience who work for local authorities and claimants will be pretty familiar with all of this. And I'm simply putting this out there as possibly, you know, a helpful checklist of the kind of things that one might want to discuss with one's clients and also with the other side as a last-ditch attempt, or a series of last-ditch attempts to diffuse a difficult situation. Because when all is said and done, you know, almost anything is better than a judicial review or an ombudsman investigation for everybody involved. And you know, of course, not all conflict can be avoided, but in this day and age, you know, a social services authority really ought to be able to avoid going to a case, going to court, or being taken to court, or to an ombudsman, without having undertaken really a better than lawful assessment, without having taken every proportionate step to avoid that occurrence. So that's a sort of my mixture of the law and guidance and practical advice. If that's going to be some help. That's the end of my slides. I'm delighted to introduce the next and final speaker, Ben Fulbrook, who many of you will recollect talked about judicial review and social care last time. And I'm very hopeful that what he said about judicial review and what he's about to say about data protection and social care will find their way into the next adult and children's social care books. Ben was called to the bar in 2016 and has garnered a fantastic reputation since then in the public law field, undertaking numerous cases in this particular area of data protection and social care, but also in immigration, in education, under the Equality Act, and in social care cases. And he's now going to speak about one of these issues, which I think we all rather dread in the social care field, and really want somebody to come along and just tell us all about it. And now I'm particularly delighted it's actually going to happen, Ben.
Thanks very much, Stephen. I'll just take control of the PowerPoint. There we go. Yeah, Steve said whenever someone mentions GDPR to me, you work in social care profession as well. And I've got 15 minutes, which is not long enough to cover all the elements of GDPR and how you should be applying them. This is really a bit of a taster of some of the law on GDPR. There is quite a lot of helpful guidance out there from the Information Commissioner in particular about some of the GDPR provisions that might apply particularly to those who work in health and social care. And I would advise looking at those. They're probably a lot better than this talk is going to be, but I'm certainly going to deal with some of the main issues. So broadly, what I'd like to do is explain, first of all, how broad the GDPR regulations are. So how much activity and data they actually capture, just to give you a flavour for that. Then a bit about, well, why it matters that obviously we comply with the GDPR. And then I will talk about some of the particular provisions that might apply in the social care and health context. As you can see on the slide there are two main sources of law on data protection at the moment in the UK. There is the GDPR itself, and then there's the Data Protection Act 2018, which has the effect of implementing the GDPR into UK law, but it also supplements it, because what the GDPR does is it leaves some scope for member states to define their own particular opt-outs and exemptions in circumstances where data can be processed. And the Data Protection Act, DPA, sort of fills that gap. So they're both complementary sources of law, and you do need to look at both really to understand the whole picture. And unfortunately, probably, but although GDPR is a good thing as well, but it is very difficult. This will still be relevant post-Brexit. It's very complicated as to why it is, but and I'm not going to go into that, but the point is it will broadly still be relevant post-Brexit. Data protection in the UK is not expected to change significantly, so it is worth listening to this presentation. And the final point is, there are obviously, you'll probably all know that if you breach the GDPR, you have to report yourself to the Information Commissioner, and you can be fined very substantial sums of money, and even public authorities have been fined large sums of money. But it's not just the fines, but also the reputational damage that comes with it. If you're known as an authority or an organisation that can't be trusted with people's data, that can be very, very damaging for you. So GDPR clearly is very important. It's also very broad. So the GDPR regulations apply to the processing of personal data by a controller or processor in the EU, regardless of whether the processing takes place in the EU. So it's where the processor or the controller is, not where the processing takes place. And now there's some important definitions there which I'm going to take you through. Personal data, which I'll come back to, is defined as any information relating to a data subject. As I said, I'll come back to that in the next slide. But a data subject is the identified or identifiable person to whom the personal data relates. It's a slightly circular definition, but what it means is it's information that can be connected to a person who can be identified. So if it's a photo of the front of someone's house, and it's a standard house, and you've got nothing, there's absolutely nothing to connect it to any particular area or location, it's not personal data because you can't identify a person with it. But if it's my name and address, then clearly it is. And to unpack that a bit more, these terms identified or identifiable person are important. So that's a person who can be identified directly. So, you know, my name and my address is very easy to identify me from that. Or indirectly by a reference to an identifier or a reference number. So say you have my national insurance number, for example, you wouldn't know directly who I am, but you might be able to work out who I am by looking by obtaining access to certain databases, and that'd be called indirect identification, where you have something and you can use other information that is out there to affect an identification of that person. Now, but that will only be personal data where you use means which are reasonably likely to be used to identify a person. So, for example, if you have a particular piece of data about me, say some internet cookie, but the only way you could find out that I've been the person accessing that website is to go to this website provider and access data which is held by them on a very secure basis, which they don't share with other people ever, then it's unlikely that you could identify that is means that is reasonably available to you. However, there has been some case law on this, and the courts are taking the position that we're quite a broad approach to even indirect identification. So IP addresses are a really good example, but they've come up twice in cases. So in Mearcom and Virgin Media, the court suggested, I think this was Obiter, but that an IP address could be personal data, because if you have an IP address, you could go to their internet service, a person's internet service provider, and identify the person who owns that IP address. And therefore, you can be indirectly identified. And even though it's not straightforward, so you can't just take an IP address and go, some questions might be asked if you're trying to track down someone and you're just an ordinary member of the public from their IP address, you can do it. That's what they said. So it's quite a broad, and it actually goes even further. So if you look at the case of Breyer, that's about dynamic IP addresses, which I think are even more niche than our sort of fixed IP addresses. And there was legislation in Germany that said that the internet service provider, or things website providers, had to disclose those to the authorities in cases of emergency, but only in cases of emergency. And even there, even though it's so difficult to get hold of that information, the court said that would still amount to a means reasonably likely to be used, and therefore it was personal data. So quite a lot of things might be personal data, and if you're thinking about those, I mean, there are obvious things like number plates, national insurance numbers, things like that, some email addresses. I mean, an interesting question is if you have an email address that has your name, like bfullbrook@landmarkchambers.co.uk, then obviously that's personal data because you could easily identify me from that. But if it was imtall@yahoo.com, it'd be much more difficult, and you need some access to some particular data sets to do that. So query whether that would be personal data. And then this term relating to is the final thing, because it has to be data, to be personal data. Not only does it be data that identifies a subject, but it has to relate to them in some way. So you know my name. So if I told you my name is Ben Fulbrook, I'm giving you personal data, but on its own, that just helps you to know that I'm a person that exists. But if you said, Ben Fulbrook likes windsurfing, for example, then that you know something about me, and that's the point that has been made with relating to. And there's been a bit of mixed case on that. There's a strong case called Durant, which is helpful, I think, if you're a public authority, because it says that it doesn't apply to any information that mentions you. It's only information that has a sort of connection to you in some way. So if you're, in that case, Durant, I think the claimant had made a complaint to the Financial Services Authority, and they produced a whole load of information. Now, it was suggested that all of the information that had been produced in response to his complaint was personal data relating to him, but the court found it wasn't, because just the fact that he'd initiated the complaint didn't mean that the data in response to it, which talked about a whole load of policies, I think, to do with his bank, was personal to him. But I think that case has been rather confined to its facts. And if you see later cases like TLT, they take a slightly different view and a much broader view. So the short answer, having talked about that for a while, is it's very broad, and therefore you need to treat information quite carefully, even if you might think it's not necessarily information that is personal. So other definitions then, another important one is processing. Again, it's very widely defined. It covers collecting, just recording, so just writing something down, storing, using, erasing, and data as well. All of that amounts to processing data. So the GDPR will apply when you're doing any of those activities to any of that very broad range of data. A controller is someone who determines the means and purposes, means of processing personal data. So most providers will be controllers. A processor is someone who processes it. So these are some of the key principles of GDPR. I think for time purposes, I'm not going to talk through all of them, but this is what the GDPR is intended to achieve. I think often it's seen as being an obstacle rather than something that's of benefit. It is intended to assist both controllers, data controllers, and obviously individual data subjects. So it wants to promote lawfulness, fairness, and transparency. The point is that you should be able to understand as an individual how your data is going to be used and what the circumstances are where your data might be disclosed to another person. And the GDPR is designed to provide a sort of framework, a transparent framework for you to be able to understand that. The second is personal purpose limitation, so that it establishes tight controls on how and for what purposes your data can be used. So that if I give my data to some online shop, they can't just do whatever they want to it, and they can only do it for certain purposes. Data minimization, so that you should store as little or process as little personal data as is necessary, because that enhances protection. Similarly, for storage, there's no point storing more personal data than is necessary. Again, it protects the data subject and protects their privacy, integrity, and confidentiality. A similar point, if you're storing data, you need to store it confidentially and securely. And then accountability. If it goes wrong, the processor, the controller needs to own up, and there need to be consequences for them. And they also need to demonstrate clearly and consistently that they are applying proper procedures. So, processing. Article 6 of the GDPR applies to the processing of personal data. So if you are a social care provider, for example, you will have a lot of personal data, and you will definitely be processing it, because every time you take somebody's name, you've got personal data and you've processed it. There are only certain circumstances where you can lawfully process personal data. The list I provided here is not an exhaustive list, but it's, as I said, I mean, the key one that you'd usually see used is consent. So, for example, whenever you go onto some website, you get a really annoying box now, including on Landmark Chambers' website, says, you know, we are going to take personal data from you and we're going to use it for X, Y, and Z purposes. Do you consent? And you just click agree. I'm sure very few people ever read it, but you know, you've given consent. But the thing with consent, again, is that it has to be freely given, specific, informed, and unambiguous. So these are really important principles, and we'll come back to the issue of consent and some of the difficulties that arise with that later. You might think consent is easy. It's actually not at all. Then where it's necessary for compliance with the legal obligation to which the controller is subject. So if you're subject to a legal obligation to provide care or pass on certain information to X, Y, and Z, then that is a lawful basis for processing. Where it's necessary for protecting the vital interests of the data subject, that really is life and death. So if you need to, you have a patient that arrives in your care home, they have a heart attack, and they're dying, the ambulance service comes, and you need to tell them, you know, what their blood group is, or they're allergic to penicillin or something, and quite obviously that's something that you can do without thinking about it because it's vital. It's necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller or a third party. That is quite commonly used exception for public authorities, obviously, and it's necessary for the performance of contract. That's quite common in, for example, if you're a private care home and you've got contractual obligations, then clearly you may have some purposes for using personal data. And there you go. So a little bit more about the performance of tasks carried out in the public interest. The Data Protection Act clarifies that these include processing that is necessary for the exercise of a function conferred by enactment or rule of law. And the ICO guidance makes clear that you don't have to have a specific statutory power to use the data, but it's when you're exercising an underlying statutory power or function, that gives you, so if you were putting that is necessary for the purposes of that, then that is the basis for processing data. But remember, it must be necessary. So it means that and that requires a lot of thought. No reasonable less intrusive means are available. That's what necessary means. So you need to think, do I really need this data? Do I need to store it? Do I need to share it? Further guidance is provided by the ICO, but I think for the purpose of time, I won't take you through all of it now. This is important. Issues with consent for public authorities. Now, as I've said, there's a lot that applies to consent. A person needs to know exactly what they're consenting to, and they need to give explicit consent. It's not good enough for a person to say you had implied consent because they read the notice and they carried on. They need to actively give their consent to you, and it needs to be recorded and it needs to be stored. Now, but public authorities have great difficulty obtaining lawful consent because of what the GDPR says in recital 43. So where a controller is a public authority, it says there's likely to be a clear imbalance between it and the data subject, and therefore it's unlikely that consent can be freely given. And that's another point I should raise, that consent needs to be freely given. When you're dealing with a public authority, it's quite unlikely that you are giving free consent because the public authority might be performing some mandatory obligation or might be providing a service which you need to take. You don't have the opportunity to just walk away. And as you can see in the second bullet point, consent can be freely given where you have a genuine choice, and you can refuse to give consent without any detriment to you. Otherwise, you're not deemed to have given consent under the GDPR. And for that reason, the ICO actively discourages public authorities from relying on consent and advises them to look to other grounds for processing data. So some of the other grounds in Article 6. And as I said, where consent is obtained, it must be recorded. Now, as well as being personal data generally, in the health and social care context in particular, you will come across data which falls within some of the special categories of personal data. They're defined in Article 9 of the GDPR. As you can see there, those special, there is a general prohibition on any processing of special categories of personal data, subject to some exceptions, which I'll talk through. Those special categories, some of them are listed there, but they include also data concerning health, and that's defined in the GDPR as personal data related to the physical or mental health of a natural person, including the provision of healthcare services, which reveal information about the person's health status. So that is quite broadly defined, and yes, the GDPR, the ICO provides further guidance on that, but it's it goes as far as obvious information on injury and disease, medical examination data, but also information collected from a person when they register for health services, and also even appointment details, reminders, invoices, anything that will tell you something about the health of an individual. So you know that I had a doctor's appointment on Monday, that could be health data. And it also includes an NHS number, for example. Now, if you're dealing with those, then you need to know what those exceptions are, because otherwise you can't even record that data. So in order to process that data, you need to fall within one of the exceptions in Article 9, and also you need to have one of the legal grounds for processing the data in Article 6 that I've already talked about. The first one is explicit consent, and I've talked about some of the difficulties involved with that. Then you have purposes necessary for the purposes of carrying out obligations and exercising specific rights of the controller in the field of employment, social security and social protection law. So that comes up a little in the health and social care context, because yes, it applies particularly to social security and the provision of social support. And again, there's guidance, which is what I'm just looking at now, on the ICO's website about that. So I'd refer you to that rather than take up too much more of your time on it. Again, you've got vital interests, and the person is, and the person is capable of giving consent for the purposes of preventative or occupational health or social care, subject to conditions and safeguards referred to in paragraph 3. And in the UK, the Data Protection Act adds another condition, which is whereby or under the responsibility of a health professional or a social work professional, or by any other person who in those circumstances owes a duty of confidentiality under enactment or rule of law. And there is in fact a definition of healthcare professional provided in section 204 of the Data Protection Act. Includes doctors, nurses, midwives. It's a very broad list. It includes arts therapists, and it includes social workers and speech and language therapists. So again, a broad range of people. And to rely on B and H, for example, that I've put in there, you must also meet one of the conditions specified in Schedule 1, Part 1 of the DPA. And I should mention as well, because it's not on the slide, but it's relevant, Article 9(2)(g), which is where processing is necessary for reasons of substantial public interest, which are proportionate to the aim pursued. Because the Data Protection Act fills in the gaps and says a bit more about what a substantial public interest is. And I'm just looking for those now. Oh yeah. So those will include where you need to process data for the purposes of safeguarding children and individuals at risk. There are a long list of criteria that you have to fulfill to rely on that exemption, and they are contained in Schedule 2, paragraph 18 of the Data Protection Act 2018. But it's important to remember that that exemption exists because clearly social care health providers will have important safeguarding responsibilities, and the GDPR isn't intended to interfere with those. So, yes, these are the conditions in Schedule 1 of the Data Protection Act that you need to meet to rely on those key exemptions, and this is one of the health and social care purposes condition, that the processing is necessary, and remember that necessary word imports quite a lot of meaning, for health and social care purposes, and it defines health and social care purposes there, again, quite broadly, and will cover the provision of social care, for example. So that's a count through. As I said, there's much more that I could say about data protection. I'm sure there's a lot more you want me to say about it, but for the purposes of time, I won't. I'll just leave you with some tips. There are lots of organisations out there who will kind of, I'm sure, tell you, and I'm sure you've already done that, will tell you how to set up your organisation in a GDPR compliant way, but it's very important that you have proper processes in place and that people who are processing data understand those processes and understand why they're important, understand the consequences of processing data unlawfully. So that's a very important point. Also, clearly, if you're going to be taking consent from people, you need to take great care that that consent is freely given, that it's recorded, that it's unambiguous, etc., that it meets all the requirements of the GDPR. And if you're a public authority, you need to take particular care, and advice would be to see whether you can actually justify processing the data on other grounds. That's most of my bullet points has come in a different order, but another important thing, and some of the work that I've been doing is in I work on the independent inquiry to child sex abuse, and some of the evidence that we've received on that from care providers, particularly relating to children, is that the GDPR has made it more difficult, just as progress was being made in data sharing between different agencies, that the GDPR has come in and made that more difficult again, because agencies are really reluctant to share information about children or people at risk for fear of breaching GDPR. I think the point is that GDPR is not there to prevent the sharing of information where that is necessary. It just imposes a framework for doing so. And so, for example, if you have safeguarding concerns about patient there is a framework and a mechanism, is that you and your staff understand in a lot of detail really what circumstances, and you have a clear process for what circumstances you can share that information in. That's the end of my presentation. I hope you caught that. My computer's telling me my internet's sort of in and out, but I'll hand you back to Stephen now.
Great, thank you. That was really interesting. There aren't any questions as far as I can see, which is kind of understandable because it's a long end to the day. There's been a lot to take on.
We have one question, Stephen, if you're interested.
Okay, I can't see it on my chat thing, that's all. But
yeah, I think it's come directly to me because it's continuing healthcare. But we've got one in relation to what does a local authority do when there are two CCGs denying that they're the responsible commissioner? And furthermore, if you try and resolve the dispute through ADR, will that be a good reason to delay, even if it takes it beyond 3 months from the decision? I think the starting point is it shouldn't be that hard. Try and convince the CCG just to figure out which GP surgery that the individual is registered at, and that should be an answer. But what's an odd situation about this is that there is a dispute resolution mechanism in the statute that goes to the Secretary of State between CCGs, but there isn't one for local authorities. So the CCGs can are able to create a dispute that goes to the Secretary of State, and then you should encourage them to do that, but have one of them undertake the CHC eligibility assessment up front and then deal with who's actually responsible after. That's the way it should be done, but I know in practice it can be more difficult. The other way is just to suggest some kind of mediation between everyone. That's another way of dealing with it. In relation to the delay, I think it's fact specific. I mean, a court isn't going to be critical if genuine attempts are made to settle things, but I wouldn't leave it longer than 3 months before actually issuing unless there's a further decision made, essentially, because you just run the risk of a point being taken. So I think hopefully that's the answer, but try and get the CCGs to sort out is my overall advice.
And there's a trap for the unwary in there as well, isn't there? I can't remember the full case citation, but I know it involved Worcestershire, who totally understandably, but they spent years trying to get CCGA to cough up for what were clearly health needs for an individual that the local authority was paying for. And everybody agreed that it was CCGA that was responsible, including another CCGB, that was on the scene. It later turned out that it was actually CCGB all along, the second CCG. And because Worcestershire hadn't actually made a claim against them, they ended up being seriously out of pocket for many years, because I think there are very strict limits on retrospective claims from CCGs. So it may not arise exactly in the scenario that we've just been discussing, but if I think local authorities have to be really careful to make sure that every possible CCG is sort of in the frame and knows that if the other CCG isn't responsible, they are, and a claim's going to be made against them. I don't know if anyone else remembers that case.
Laura has messaged the name. It's a Wolverhampton case. I think that's right. It's David Locke was in it and ran a very technical ultra-virus argument on which he won, I think was the case. It's Wolverhampton is in the chat now.
He acted for CCGB, the
one who was paying, I think.
Sorry, CCGA, who came along at the last minute, yeah. and I ended up acting after that case was over for the poor local authority to try to get money from the CCG, which all along was responsible, but nobody quite realised that. And whilst we did get money out of them, it was a very difficult process, and it was only a fraction really of the total cost. So I mean, there is a, thank you, Laura, and there's a real trap for the unwary there. So make sure when you're a local authority that if there's any chance that it's some other CCG that's involved, that your claim is registered with them at the earliest possible stage. Because if you look at the relevant guidance, their ability to pay retrospectively on one view is incredibly restricted. Oh, we've got, hang on, we've got some questions which have just sort of come up. The system doesn't provide an equal footing for those having to do with public authorities. What do you think can be done in practice to help? Well, that is something we've all come across. Okay, well, just very briefly, you know, hopefully you'll get a local authority that takes its responsibilities very seriously. But if there are difficulties, you know, CABs, law centres, solicitors on legal aid, ultimately the complaints process and the ombudsman. And in my experience, the ombudsman is actually far more of a concern to local authorities these days than judicial review, because the approach is significantly more intrusive and is significantly more judgmental in every possible way. So those are the things that can, in my experience, level up the playing field. So, and there's another question. If someone refused the Care Act assessment and the exceptions in Section 11 requiring an assessment to be carried out don't apply, this is probably for you, Ben, or do you see it? Lawful basis, I think it must mean, what is the lawful basis under the GDPR for processing their data, including keeping records of contact made with them to offer assessment? Would it still be a public task?
I can't give you a definitive answer to that, I'm afraid. I'd love to. But I think the point to consider is there's a difference, obviously, between consent to the Care Act assessment and consent to the processing data. It might be that the client doesn't give consent to either of those things, so they don't consent to the processing of personal data, in which case, and indeed they may not be able to if you're a public authority, in which case you would need to see if you could rely on another basis. And I suspect the one you'd rely on would be that you have a legal duty to keep those records. And I can't give you anything more than that off the top of my head, but that's probably the path that you would go down.
I'm sure that must be right. Okay. I don't think, I can't see any more questions. It may be that one of you guys have had a question sent direct to you, which I can't see. But if that's not the case, well.
Sorry, Stephen, I have had one directly to me.
Oh, okay, go on then.
GDPR again. So GDPR has come a couple of times when the local authority has deputyship for finances for a client and are going to represent in a community care matter, and we're trying to obtain legal aid evidence. Do you think there are any specific exemptions that would apply in these circumstances to use in a response to the local authority? I'd love to be able to give you an answer to that, Emma, as well, but I don't, I'm afraid. No, I could try and look that up for you, but I can't off the top of my head give you, maybe one of my colleagues can help with that, but
I think maybe we'll have to get back to everyone on that one.
We'll have to get back on that.
Right. As I was saying, unless anybody's got, are there any other questions that have come direct to anybody? No. Well, this is our last webinar for a little while. I think we've all really enjoyed doing them, and it's been great that so many people have taken the time to sort of look at them as we've been delivering them, and also sort of later on the website and on YouTube. So on behalf of us all, thank you so much for joining in, and you know, have a lovely weekend. Thank you very much. Bye-bye.